A nation that prides itself on constitutional values, suddenly turning its back on one of its most marginalized communities in the dead of night. That is exactly what unfolded in Parliament when the Transgender Persons Protection of Rights Amendment Bill 2026 was rushed through, with the Lok Sabha passing it by voice vote amid an opposition walkout and the Rajya Sabha following suit the next day. Marketed by the government as an administrative correction to tighten definitions and prevent misuse, this legislation is nothing short of a constitutional betrayal. It strips away the hard-won right to self-identification, replaces it with invasive medical gatekeeping, and narrows the very definition of who qualifies as transgender. It contradicts the Supreme Court's landmark 2014 NALSA judgment, violates fundamental rights under Articles 14, 15, 19, and 21 of the Constitution, and pushes India's transgender community, already among the most marginalized, back into legal invisibility and social erasure. In this detailed critique, I expose the bill's flaws, its dangerous implications, and why it represents a dangerous regression rather than reform. To understand the damage, one must recall the legal foundation this bill seeks to dismantle. In National Legal Services Authority versus Union of India in 2014, the Supreme Court recognized transgender persons as a third gender entitled to all fundamental rights. It explicitly affirmed the right to self-perceived gender identity as an integral part of personal autonomy, dignity, and privacy under Article 21. The court directed governments to frame laws for legal recognition without unnecessary barriers. The Transgender Persons Protection of Rights Act 2019 was Parliament's response, flawed in many ways, including its failure to ban conversion therapy or provide robust reservations. But it at least enshrined self-identification in Section 4.2. A transgender person could apply to the district magistrate for a certificate based on self-declaration without mandatory medical proof. This aligned, however imperfectly, with global human rights standards and the lived reality of a community facing extreme discrimination, violence, and exclusion from education, employment, and healthcare. Yet the 2026 amendment tears this down. Its statement of objects and reasons claims the 2019 Act's definition was vague, leading to implementation difficulties and incompatibility with other laws. It argues the law was never meant to cover every class of persons with various gender identities, self-perceived sex or gender identities, or gender fluidities, but only those facing severe social exclusion due to biological reasons for no fault of their own and no choice of their own. This framing is not just factually misleading, it is ideologically loaded, reducing gender identity to biology or traditional socio-cultural roles while dismissing self-perception as a mere choice. Section 2 of the amendment substitutes a drastically narrower definition of transgender person. It now limits recognition to persons with specific socio-cultural identities, such as Kinnar, Hijra, Aravani, Jogta, or Eunuch. Those with listed intersex variations or congenital differences in primary sexual characteristics, external genitalia, chromosomal patterns, gonadal development, endogenous hormone production, or other medical conditions, or anyone compelled by force, allurement, deceit, or undue influence to assume a transgender identity through mutilation, castration, or similar procedures. Crucially, the proviso explicitly excludes persons with different sexual orientations and self-perceived sexual identities. The bill omits the 2019 Act's inclusive language covering trans men, trans women regardless of surgery or therapy, genderqueer persons, and anyone whose gender does not match the one assigned at birth. This is erasure by legislative fiat. Trans men and trans women who do not fit traditional Hijra Guruchela systems or specific biological markers are now outside the law's protection. Non-binary and gender-fluid individuals, whose identities are as valid and innate as any other, disappear entirely. The bill medicalizes and pathologizes identity, demanding proof of congenital variation or forced procedure rather than respecting self-declaration. It revives a pre-2014 biological essentialism that the Supreme Court had decisively rejected. Gender identity is not a choice or a Western import. Decades of medical and psychological consensus, including from the World Health Organization, affirm it as a deeply felt intrinsic aspect of human diversity. By privileging only biological reasons, the government ignores the lived experiences of millions who transition socially, hormonally, or surgically without fitting neat medical checkboxes. Even more insidious is the replacement of self-identification with mandatory medical certification. The amendment introduces an authority, a medical board headed by a chief medical officer or Deputy Chief Medical Officer and amend Section 6 to require the district magistrate to examine the board's recommendation and, if deemed necessary, consult additional experts before issuing any certificate. Section 4.2's self-identification clause is simply deleted. Post-surgery, hospitals must now report details to the district magistrate and the board, and revised gender certificates become compulsory rather than optional. What was once an administrative process has become a bureaucratic and clinical gauntlet. Invasive examinations, potential delays, denial of access in rural or under-resourced areas, and exposure to bias from medical professionals untrained in gender-affirming care. This gatekeeping humiliates and endangers. Transgender persons already face rampant stigma in hospitals. Requiring genital exams or chromosomal tests revives the very pathologization the community fought to escape. It creates insurmountable barriers for the poor, illiterate, or those without documentation, precisely the most vulnerable. Corruption and arbitrary refusals are inevitable. Privacy is shredded by mandatory hospital reporting. And for what? To protect genuine beneficiaries, the government claims. Yet the real effect is to shrink the community eligible for welfare schemes, reservations, anti-discrimination protections, and identity documents. Thousands who relied on 2019 certificates will now be forced to reapply under stricter rules or lose legal recognition altogether. The bill's new offences under the substituted Section 18 add graded punishments for forced labour, denial of public access, eviction, abuse, and especially kidnapping or coercion to adopt a transgender identity, with life imprisonment possible for child cases. On the surface, harsher penalties for genuine exploitation sound progressive, but in context, they serve the narrower definition. The law now polices who can legitimately be transgender while criminalizing forcing someone into it. This could be weaponized against families, communities, or even well-intentioned support networks, while failing to address everyday violence faced by those now excluded from the definition. Critics from the transgender community, including activists who helped draft the 2019 Act, have rightly called the process undemocratic. No wide consultation occurred. The bill was introduced on March 13, 2026 and bulldozed through within days, ignoring voices from Tamil Nadu's Tirunangai and Tirunambi communities or urban trans youth whose identities do not map onto listed socio-cultural terms. It divides the community into authentic traditional groups versus inauthentic self-identified ones, a classic divide and rule tactic that weakens collective advocacy. The broader implications are chilling. Without certificates, transgender persons lose access to education quotas, government jobs, healthcare schemes, and even basic banking or travel documents. Discrimination in housing, employment, and public spaces, already rampant, will intensify as legal protections shrink. The bill contradicts the right to privacy under the Puttaswamy judgment of 2017 and equality before law. It flouts India's international commitments under the Yogyakarta principles on gender identity. Politically, it signals a narrowing vision of citizenship that prioritizes biological determinism over lived dignity, potentially emboldening vigilante violence and social ostracism. The government's rationale collapses under scrutiny. Implementation difficulties with the 2019 Act stem not from vagueness but from state apathy, lack of sensitization, and societal prejudice. If misuse occurred, targeted rules, not wholesale erasure, were the answer. Claiming self-identification protects acquirable characteristics ignores that gender dysphoria and identity are not chosen like fashion, they are enduring. By reverting to a pre-NALSA mindset, the bill does not protect the vulnerable, it abandons the diverse modern transgender population to fend for itself. In conclusion, the Transgender Persons Protection of Rights Amendment Bill 2026 is not reform, it is regression. It replaces constitutional self-determination with state-sanctioned medical surveillance, erases non-conforming identities, and betrays the promise of inclusion. India's transgender community has endured centuries of marginalization, from colonial criminalization under Section 377 to everyday brutality. This bill compounds that trauma. Parliament must repeal or substantially amend it, restoring self-identification and broadening protections through genuine consultation. Until then, this legislation stands as a stark reminder that rights, once granted, can be clawed back, unless citizens demand better. The fight for true equality continues, but the 2026 amendment has made it harder, more painful, and more urgent.